So first of all, I would like us to look at examples of third parties, just to get a better understanding of who these people are. That is what we are addressing today. One contact with who is not you, and the other assumption is that that person is also not like your employee. They're not integrated into your business. These are third parties inside your business vehicle, but they are providing something that is very important or integral to your business. So examples of these third parties could be, technical service providers. So these are people that you need. So my understanding is that most of you are in medical hardware development. And so for some of those, you need technical service providers. So it could be, examples could be like software programmers, people who, you need a certain software that will be used with your hardware to actually deliver. So promising, you might have, engineers or designers who are actually designing and fabricating your product, right? So you have those which could include fabricators, technician, and this category, the technical services providers, this category are people who are part of creating work, creation of products that you're selling. So these are very critical third party providers, and they
Felicia, I don't know whether it's
your
from my end.
Yes.
You seem to be breaking a bit at some point.
Okay. All right. Sorry, can you hear me now?
Yes, hopefully you will not break. Okay. Yeah, go ahead.
Okay. I hope you had the first part in you, but that these technical service providers are the ones who are usually can cause a lot of problems to your entire business, because what you to the development or to the functioning of the products that you're selling. And so these ones have the potential to really bring you problems if you don't engage with. I mean, having clarity in what they're providing, how it is delivered to you, how you pay, how they support, how you terminate, and the transition process. So we're going to look in detail. In fact, the contract clauses that we're going to look at, most of them we will use these technical service providers as the examples that we give. The other type of third parties is creative marketing and content providers. So this is now more of marketing and towards marketing and publicizing your products. So these are your influencers and what. And then also there is third party in the form of sales and distribution. So there are businesses where the sales department is in-house, and then there are also businesses, especially at the beginning, you might decide to outsource that and get sales agents who you most likely will be paying based on commissions, perhaps a fee pegged on the price they're able to sell. And other examples include distributors. This again depends on the product that you're selling. You have resellers, franchisees. This is now a business that is phase. You have already established your goodwill, and now you want to expand, and this is the strategy that you've decided to adopt. Other third parties include payment service providers. So these are your mobile network operators, which now, I think mostly for startups, these are critical payment service providers. You have payment aggregators, banks, and even international PSPs, your Visa, these are also very critical third-party providers because they can also cripple your business if you cannot receive payments or you can't. There's a problem. Some of them have extensive powers in their standard terms where they even write that they have a unilateral right to suspend your account. And at that time, maybe you have money in your wallet there which you have not withdrawn, which perhaps you need to pay something else, be able to deliver on your product, and you find that they have suspended your account and they're not giving you any reasons. You chase them and they take you around, etc. So these service providers are also very crucial and can also cause a lot of problems if you don't sign a good contract with them. Higher. The others are administrative services. So you're outsourcing more of these administrative functions, for example, accountants, auditors, human resource, tax advisors, legal advisors like myself. This one you might find at the beginning stages of your business, you might find you're outsourcing also a lot of these administrative functions. And mostly here, the concern is just usually professional, the ethics of the service provider, negligence, negligence. This is where perhaps they misadvise you, and then also like issues around data protection. So we're going to discuss this as we go along. The other type of third-party parties is data protection, is now big, especially in your field, in the health sector. Health data is sensitive, falls under the sensitive personal data, which means it has heightened security provisions. And so this is a very, very important, they're also a very important third-party providers. So anyway, this is just a broad category. They can be more than these ones. And I don't know whether anyone would like to add a different category. Okay. All right. So we can move on. In case you have any other type and maybe a specific query concerning your engagement with, you can always raise it at a point during discussion. So these are some of the examples. Now we're going to move on to see how do you deal with this. Okay, it has moved. All right. So also, I want to start by just looking at the common mistakes so that when we now get into the different ways of contracting and the different key provisions in a contract, then if you've made any of these mistakes, or if it's a decision that you're about to make, then you can relate it, you can tie it in, and hopefully have a better solution for your current problem. So some of the common mistakes that many startups, and not even just startups actually, and just business people generally, some of the common mistakes made in contracting with parties is not having an agreement in the first place, where you meet, you have a discussion, you say, let's start, you start this day, someone says pay a deposit, you send the money, and then they start working. There is no agreement setting out the terms expressly, so everyone is relying on a conversation that they had at the beginning. The problem with this is, should there be any issues, including simple things like what exactly were you to deliver, you might be thinking one thing when you're entering into that contract and even paying a deposit, and the supplier was thinking something. So the product they deliver to you, what you thought you were getting, it's something completely different and will not serve your purposes at all. So when you come there and you're having a discussion, you're saying, this is not what we contracted for. If there was nothing written, then it's a she said sort of thing. I said this, you say this. Maybe it was the two of you in that meeting, so there is no witness who can come and even provide like a or watch for one perspective. If you don't have the it can lead to heavy loss, especially if what you are contracting for is something that is crucial to your business or to you launching your product. Another common is the manner in which you contract that third party. It is very common, especially during like this startup phase. You meet someone. So there could be, for example, there are founders in the business. You can registered as a company. There are 3 of you, and then down the line you meet somebody else who has a certain expertise that you need, and you have it could be something that's written, and this person starts working for you, and they become an integrated part of that business. Where, and when you're speaking, you're saying, yes, we are collaborating, or we are partnering in this. It is, and it could be that in your mind, this company, we are 3 founders and this guy who's helping us. But if in actual sense, the way you were engaging and the things that you were saying conjured different meanings, and it can also give you a lot of problems down the road, because you can bring somebody, maybe now you're doing the designs, but none of you was a programmer. You find a software programmer, add him in, and then at some point, you even tell him, show up, you have to come between 7 and 3. 7 a.m. and 3 p.m. You issue him with a computer, a company computer. You have him you even send an HR manual so that he can see what some processes, how you deal in that company. You're always inquiring, you're giving him perspective on how you do things there. You find that even if you're saying this is an independent contractor, in reality, should there be an issue, they can go to court and say they were unfairly terminated, and they would be claiming that they were in fact employees. And if court agrees with them that in fact employees, then in a termination, the company would have to pay the employee benefits, which is something that people, which is, if you did not intend to have this person as an employee, and now you're in court being sued for unfair termination, you'll have to provide all the benefits for employees and stuff like that, which is something that might not even be something the company can afford at an early stage. So it's very important to think about the manner within which you engage. Most times it's very vague, very loose. Let's partner. Even if it's not an employee, you can, and then it's as if you are doing it together in a partnership. So that creates liabilities on you, because a common law partnership is one where the partners are liable to each other's liabilities. So you can be held liable for somebody in your mind you did not intend to bring in as a partner in the legal sense. Right, so those are some of the common mistakes. And also another problem with that is, say, think about ownership of IP. And if it's deemed that this was done in a partnership, that might be extended to that. This IP was joint IP. So they have also significant the IP that you've developed together. So, and that could raise problems, especially if there's a separation. Another one is using informal agreements, which is very common, and this is so, especially if you have a relationship with a person that you're engaging with, it's very easy to be informal with that person. You just send WhatsApp messages, or in an email correspondence, how much price X, that's it, let's do it. You pay the deposit, they start. But then you don't flesh out the details, because maybe you have said this one could never, this is my brother, sister, I can never double cross another thing. So the informality, that's very common, and it's something that also has very dire consequences, especially if the fall and whatever you're contracting for is crucial to your business. Another common mistake is where the deliverables are not properly outlined. Now, this is a major issue particularly for software development agreements, when you're not clear about what it is that that developer is building for you, then when you receive it and it's not working, you want to complain. But even if you had an agreement, description of the service to be provided was very vague or very broad, so it could be interpreted in any way, then you could find, you could also lose out quite a bit if what you were expecting or what was actually being contracted for was not clearly outlined. Another one is acceptance test. So if you don't have an acceptance like detailed acceptance test, and say using those same software development agreements, you can have, like, you're building different modules perhaps for your functionality. There's a startup from Uganda doing some neonatal maternal, like, very nice incubators that you wear, a mother wears. So it has different components or different modules, kind of software that they need for their full product to work. And those are some of the things that you need even if there'd be probably software being ordered for the different components of their product. But for this solution to work, or rather to be a functional thing that you're offering to a customer, these components have worked together. So whatever modules are in each have to work together when combined. So again, if you've not thought through an acceptance test, then you can have a software programmer, he'll build for you module 1, you test on this one thing, it works. He builds for you another, you say, okay, sir, that one has worked. You do another one, this has worked. You've paid the money. The day you come to integrate them, they stop, they can't work, or there are glitches. And then you've already paid all the money. You've paid for all these different modules. And so now it's okay, fine, I do it, but you have to pay me an additional price, or we have to do this now inside another maintenance agreement or whatever. So you might find now you're spending more, you've lost time. Also, if the program again, now you can't even use what they have given you. So the consequences of just this small oversight could again be very damning to a business. Another one is assuming payment terms are secondary. If you're a customer, for you, what you need is the functionality or the service that is being provided, and your only obligation there is to pay money. So many times you might not give a lot of weight to the effect of payments on that service delivery. And this is where not usual for, okay, actually, no. Let me just say, most times a startup will also be working with other startups. Like, you'll also be working most likely with people who are also starting their own businesses or growing their own businesses. So money is a serious deal for everyone, including that service provider. So to continue, so again,
as you continue, Felicia, we've been experiencing some bit of hiccups on the internet. Hopefully that can get fixed.
Okay. I hope it will be better. I have moved position from where I was. Okay. So for on payments, so saying the problem here is you as the customer not giving weight to the importance of your timely payments to your service provider, because most likely they are at the same level as you are, and money is existence. So if you also are defaulting, or you have a very one-sided contract, then they might just actually fail to deliver because they didn't have the resources to do that. So again, it is another common mistake, another common mistake that is made. And another one also, again, is not structuring the payment clauses well, where you only think about the service, but you don't really read the payment terms very well. You might find this guy saying, pay full amount or pay 80% deposits. But then at that point, because you're thinking this is and yes, we will find the money, you pay them, and then they deliver something that is substandard, and you are unable to get your money back. So again, it's just also thinking through the payment terms to ensure that you have something that is fair. Another common mistake is where you don't have an IP clause. You have a contract, but it's very basic. It doesn't contain things like IP clauses. And you know, if the deliverable is it's a highly intellectual product, then an IP clause is very crucial for you as the customer. So again, if there's an oversight in that, then it's governed by implied terms, what exactly could be applied into it, which might not really favor you. Another common mistake, of course, is confidentiality and data protection. Data protection is important thing, especially in your sector, and it's something that you should not overlook. In fact, in any contract, however minor, you just need what personal data are we going to collect, or with this other party, what personal data will be processed, so that you can work out, from the onset who has what you apportion the obligations amongst yourself. But then this again is something that most people also don't really think about, the data protection clause or confidentiality clauses. So these are some of the mistakes. Having looked at these, we will now broadly just look at, this has moved too far. So having looked at the mistakes, I wanted us first of all just discuss quickly what I had said in the introduction about just how to structure the engagement with third parties. The main issue is, especially when you're engaging an individual, one way is when you're contracting with a third party, in that they will be independent service providers. You want to ensure that it truly remains, or in essence, is carried out or performed in a manner that truly shows that that contractor was an independent contractor. Now, the risk, as I had mentioned, is where you start controlling the third-party service provider in a manner similar to an employment relationship. And where that is deemed to have arisen an employment relationship, then you would be obligated to Act and any other employment obligations that employers have. So this is just definitions, this is just legalities as to who an independent contractor is, which essentially is that this is someone who is undertaking to perform a service for you, but independently. Like, they will do it on their own terms. All they need to do is that they deliver the work. They will do it on their own terms. They will determine the way in which they will process, and in exchange you will pay them a service. You will pay them a price for the service that is provided. For employees, I've picked this definition from the Employment Act. So if you're not Kenyan, then whatever act or law that you have governing employees, you can most likely, the definition would be something similar, where an employee is who for their skill and time, you pay them a salary, or you pay them some remuneration that is already agreed. Now, the difference with an employee is that for employees, the employer controls the manner within which they provide the service. So what the courts have established is that it doesn't matter what you say, that engagement is. So you can have a contract. In your contract but if in essence, the way they performed the service, you had a lot of control in the way within which they performed it, then it could be deemed to have raised to an relationship and held liable for some of those things. Now, this is the subject. Think of the training, the third training. So we'll get into more details on this. But I just thought it's important to mention that you have it at the back of your mind, particularly where you're engaging an individual third party. Okay. And then the other one, of course, is unclear description of third party. Terminologies like let's partner, let's collaborate, let's work together with other different people, and especially in actually now this incubator that you're in, if you might meet other people with, you discover that, oh, we have things that could complement each other, and then you just agree. While in a training session, you say, hey, let's do this together, let's develop this, because whatever we're working on is, we all need this particular solution. So you say, let's work on it together. If you're not just as simply, let's partner, it could conjure some meanings in the law that were probably not. That was the intent. Then you need to sit down and properly have clauses or agree on the manner within which you will undertake that task or that project together, so that you don't acquire some liabilities that were not intended by any party. And as I mentioned, some of the risks there is, it's deemed to be a partnership and liable people's claims, or rather partners' claims, which in your mind probably you didn't intend to, but it's something that now the law has deemed to be in existence. Particularly ownership reasons, it can be very problematic if you did not intend, like in your head, to do this together, and it can cause significant and even stop some operations, right? Especially depending on how intertwined those two are. So again, I mentioned those 3 points there: collaboration, just to explain. So here there are collaboration agreements. Mostly in a collaboration scenario, each party is coming in, it's mostly contractual. So you're each coming in with whatever you have, and agreeing to collaborate on a certain project, but each party remains independent. You have whatever it is you're bringing in remains independent, and all you have to do is agree on how you will deal with that project that you come together to do. In joint venture, most times it's more structured partnership. The different forms, you can also have like a contractual JV, but most times JV is an entity in itself. It's not like the combination, like a collaboration, which is you and this other party coming in. In a JV, it will now be you, the other party, and then as also party by itself. In partnerships, these ones we discussed last week, I think we mentioned them briefly. In partnerships, this is you're coming together, and the law will deem the together by a partner be all the partners will bear liability for it. So those are broad, or rather the general outlook on this kind of arrangements, and each of them has different types of a different format of agreement that is in the different legal aspects that relate to each and every one of them. Okay. So is there a question up to there? Any questions? Okay. And so before we get into I wanted to just do like a background on contracts. Jenny, what is a valid contract? So for a contract to be valid, there has to be terms that offered to another party, and there has to be an acceptance, which is that that party has to accept these terms that are offered, exactly those terms. So if they come and say, on principle, we did it, but on this point, let's adjust to this. If there's a variation, then they cannot have been an acceptance. So for there to be a valid acceptance, it fully the way it is. If somebody comes back with something else, then that one has to be resolved and the parties reach a meeting, and then now there can be an acceptance. The other element that's crucial is correlation, which means value has to be passing from one to the other, or one party has to be suffering admit for in exchange for what the other one is doing. Then a contract would not be valid. So again, using the example of now, say in the current cohort, you meet a number of other startup founders there. You do something, and there is no value that's passing. It's not clear what value is passing, and nobody has paid anybody anything. If there ever be a dispute and you want to say we agreed on this, there was a contract, whether verbal or oral or written, but consideration passing, it is likely that they could be able to defeat that claim by saying that there was no valid contract because there was no consideration. So it's important, any contract whatsoever, you must ensure that the value or some detriment being offered, and it should be clearly stated, so that should there ever be an issue, it can be like, yes, indeed, some value passed, which validated the contract. The other one is the intention to be legally bound, which, well, it's almost like if on the face of it is that each party intended to be legally bound, but there are cases where people have gone to court and have allowed their claims where they said they had no intention to be legally bound by this. Right. So anyway, you'll find in most contracts, if you can even think lawyers do, they have a clause in there that says each party to be legally bound. So this is like for the avoidance of doubt. Yes, everybody intends to be bound by this agreement. And another, of course, capacity, they have to be, so if it's an individual, have to be of sound mind, they have to be of legal age, whatever the age is in the jurisdiction. Within, example, in Kenya, legal age is 18. So if it's an individual, they should be at least 18, they should be of sound mind. If it's corporate, that's why it's important to properly know if then depending on the country within which you're operating, then you have to check who is authorized to sign or to bind a company in a contract. So for example, the directors of the company or an authorized person who has been authorized perhaps by a power of attorney or a resolution of the shareholders, etc. So you have to confirm that who is in most cases, even say, for example, when you're opening a bank account, the bank is asking, give us a CR12. That CR12, it's a company search. It shows details of the company, of the business, who are the directors of this business, and then they do that against the account opening forms to make sure that the people who are here are the ones who are creating this account. So it makes sense. And this is good practice to do it when you're conducting some. If it's a company, you can do your own search, you can request them to give you a CR12. right? And now it's possible you can get on, this is you and apply for a search for any company that you want there to ascertain. If you're contracting with public institution, then you have to also check they are constituting in Kenya. If you're dealing with the national government, say a parastatal, the CEO is the accounting officer. If it's a ministry, the PS is accounting officer. Yes, you know that they have power to bind that ministry. It has to be bound by a principal secretary. If it's, say, for example, the county governments, it's the chief officers who sign. Because there's no authority to sign that. So those are issues on capacity. If somebody is senile or they have mental issues, and mental issues that everyone is aware of, and you still get that person to sign, then it's a contract because they have no capacity to. Legally, this is just that what you're contracting to do is a lawful thing. It's not a crime or something against public interest. Determined based on facts, right? So the general principles on contracts, and this is now based on English common law. If you come from a country that was colonized by Britain, then most likely your court law somehow is influenced by the English common law. What the courts is that they will interpret a contract based on essentially what you say and what you do. So in writing, they will check what is it that you agree, what did you say, or even in writing, and they will also check what did you how were you behaving to determine whether the existence of that contract. So it is, if you the very important for you to think about any engagement that you're entering into, because you might not have the intention, or rather you might while saying or signing documents, and in your head you have something else, then how that contract will be looked at will not be based on what you thought. When you sign, and how are you behaving, right? So to determine the terms of that contract. And I thought to add that there that the courts will between parties, and they have paid this time and time. And actually, I think contracts, probably in the whole world, all the court, they will not rewrite any terms of a contract between the parties. So if you enter into a bargain, and as I move slides, let me just say this. This is like a side note. Many people sign contracts with the dispute resolution arbitration. You're a startup. Arbitration, number one, is expensive. Number two, at least arbitration in Kenya, and I say this not in anything, but arbitration in Kenya also is not. People also are able to influence or compromise those processes. So, arbitration, you have limited your dispute resolution to, say, an individual, and the appeal provisions from that decision of the individual are very slim. You're a startup, if you're just starting out and whatever it is you're contracting for is not crucial, don't accept arbitration clauses. Just better you have an appeal to higher. So specifically now for services contracts, because that's the subject of today's training. For services contracts especially, because and think about this, it's still an experience, an intangible service, or the delivery is something that you can't. It's not a good that you can eat or feel or touch. It is and expertise and the time of that third party provider. So essentially, there are the important things to have in your services contract is about the standard of performance services. So this is the quality of what you receive. This is essentially, it goes towards the deliverables. Just like a minimum service commitment from that third party service provider. So the reason this is here, it seems very obvious, of course, to have in a contract, but because these are things that have been heavily disputed, different things, because in the laws, although this one, it's the act here in Kenya relates to goods, sale of goods, there are things called implied terms. That fitness for purpose, and there is quality, that it meets quality and it meets specifications. These are things which people try to exclude, say like we have included all implied terms. So in your interest, it is to have them specifically included in the contract so that you can use them to gauge, to test the deliverables and determine whether you're going to accept that or not. So it's important for you to have that in. If, say, for example, this software development contracts, you have proper acceptance criteria built into your contract so that before you accept the code or the solution, the system that you're being given, you're able to test it and criteria you have with that programmer, and then the other obligations come in, say, which is most likely the obligation to pay the fee for that development. So it is critical to have this particular wording there, is because of just those issues around implied terms in terms of supply of services, supply of goods. There are technical terminologies, and which, if they are missing, what exactly the contract provided for. Okay, the other one is the time for the performance of the services. If it's not expressly stated in your agreement, then then it should have been done in reasonable time. But what is reasonable? Fact. So again, that question will be determined when now you have already, because now you to courts for them to now decide that this is what was reasonable based on the prevailing circumstances. Yeah, you probably went out of business, or you had to incur the cost of engaging another one and paying them for it. So that's why it's important to just expressly have it in there so that it doesn't become a question. Same for prices and services. You don't want a vague provision or a provision that says we will determine pay as we go, or I'll find out and then tell you how much I will charge you the line. It's not prudent for you. So for you, it's best to have the actual charges indicated, the way within. This that I've left there of variation of terms, these three things have been deemed, and it's issues that the courts have said are able to violate to the contract or the agreement that you enter to with the third party, which is, for example, one, conduct of the parties. You may have a contract that says, that has provisions and the question of interpreting what did these parties actually agree on, the courts will look at how are you guys behaving. This could be through actions, through email, through the courts can and use to interpret the contract. And then also, and here also again, it's you might have a contract that provided for one thing, and then one you just assumed we already contracted. Now do this other thing, and then you already have a past relationship. You just do something else with the contract. Then in that also parties. Another one is trade storms. This is what your industry does, what common in your industry, what something that everybody knows to be, this is how we anyway, there's some legal conditions that have met for trade custom, but that's essentially what it means. In sectors such as insurance, there are things that are trade custom that even if they're not reflected in the contract, parts of the agreement. And industries, things also like shipping and logistics, they also have a lot of trade customs. Another one now is express agreement. This is where so that you extends things or adds different, you expressly have that and it's signed by both parties. So now to look at now provisions in a contract that are important, provisions that I thought we should go through in detail, because this is essentially what you need to contracts that most of them are, most of these are that we looked at the beginning, but some of them, the provisions might change depending on the type of contract that you enter into. So of course, you always have to have that in mind to customize the different clauses for the contract you're entering into. So once the deliverables, which we had started discussing, this goes to the standard of performance. It's important that you set out specifically what you're contracting for. Because if it's not clear, then when it comes to acceptance or determining whether this contract has been performed or not, will become a dispute. What it is that you wanted. So in a contract, you want to ensure that you have properly described or given specifications for what you're to be provided with. Like as a schedule, an annex to the agreement where you set out detail what exactly it is that you're contracting the person to provide for you. In software development contracts, it can be even longer, because or rather more complicated in terms of how the description of the business requirements. So, but it's something that it's linked to the payment clause, it's linked to the acceptance clause, it's linked to so many other things in the entire contract, and it's important that you provide it so that and then provisions relating to quality. I've written best quality. Best quality is the term you want where you're the customer, but on the other side, the supplier can see that for them they will use reasonable endeavors to achieve something that is materially acceptable. But then those are commercial points. For you, it's in your interest to ensure that you get the best quality that something that's free from defects. And in the contract, you have to include things like, if there's a defect, then you have to include there an obligation for the supplier to remedy defects before at their cost, and also like something like, we will not pay until you have delivered to us products or the solution that is free from these. Also, at a broader level, this is now like a best to have, is where you also manage to put in your contract a right to reject defective products. So this is, you can have you do a test, an acceptance test on the deliverables. If they have defects, you will send it back. Give them, you specify the time within which they have to remedy. You can even give like when we had defect, you are to fix it, then I will have a right to reject delivery of goods. And if we've already paid, say, a deposit, then you receive your refund. And is fitness for purpose. Fitness for purpose, again, is a technical term in the supply of services. It's it means that I have told you what I want this, what I'm going to use the solution for. And so whatever you make for me has to be something that use. So in this case, what I mean thereby doubt by the third party, it could be that they told you they are in the business of doing that. So they represent themselves to think that will fit your purpose, or it could be that you have communicated to what exactly you need. So they know what that solution you're going to use it for. And therefore, they deliver, if they give you something that you cannot use for the purposes that you stated, then you have a right to reject delivery. So this is a specific term. It's a so it is ordinary English, it means that, but also it has like a specific terminology or a specific definition that it's given in contract. Then another important thing to in this deliverable that I have been repeating, having an acceptance procedure so that you're able to do a test on the deliverable, then possibly before you have them. Criteria, installation and testing, acceptance, go live. This is not used mostly for software development, software development agreements. So it's something that you need to be as thorough as possible. You can have it in a schedule if you think it's very detailed. You have your simple agreement, deliverables will be as provided in Schedule 1 or Schedule 2 or whatever, and then there you can put all the stories that you have. Most times in these user acceptance criteria, for development agreements, this might not be in the contracts that you sign, the development contract. It's something in there you will just say, you put a timeline there for the parties to on the acceptance criteria, because it's something you have to do together with the developer to come up with it. Okay. 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 All right. So we move to time for performance. It's in your interest as you, as the person engaging the third party, it's in your interest to have in there a start date, that is the commencement date, to have in there your completion date, because these things are important for you. You're probably planning a live or a launch based on all these different things, like the hardware, the fabrication of it, or when it's built, or it could be software, it could be whatever, all of going to market. So it's in your interest to be specific on the timeline that the supplier or the third party has, and in case it is broken down into milestones, because you can have maybe a project, it has different modules, and you want to spread out the modules, then it's good in the contract for you to have the different modules and the milestone dates, or rather by when should you have delivered this. So you can also link this again to payments. You can have an agreement to say, we will pay you per module when you achieve this milestone, then there's an installments that's payable, etc. So the clearer you have here, then it's also linked to other clauses within your contract. Again, when you're clear on the milestones and the timelines, then you can also build in a provision that you, until this is delivered, installment will not be paid. Or if there is repeat, like it is clear there were 4 things this person was to do, they have given the person that or milestone, and they keep increasing. It seems that they can never progress to module 2. Then you also can build in a right there to terminate if they are unable to deliver in time. And if, remember what I said, if timing is missing, then the court will deem that it was to be performed within reasonable time. So here you might see a terminology called of you add in the clause that time of essence in this contract for you as the customer. When you say time is of essence, then it will be relating to the performance of those the supply is able to deliver what they need to deliver within stipulated time. On the third party side, they'll probably have times of essence on their payments. So it's just most times of essence, it relates what is crucial for you. Yeah. So as a customer, that would be delivery of the services that are contracted for. Another important clause to think about is the payments clause. Just breaking it down, if you decided you're anchoring your payments on the milestones, that's what you have agreed, then it should be clearly set out. What are those milestones? What amount is payable of those? This, of course, the payment clause depends on the nature of the contract that you have. If it's like a retainer sort of thing, which it would be common with people like content creators or marketing agencies, those might have that type of thing. So the payment term would reflect. If you have, for example, the fabricators, it might be milestone based, and at each stage you're pegging it on the milestone set for square. So it just depends on the contract you have. For the payment service providers, it could be commission based. So they net off their commission every time they process a payment for you. So it depends on the contract that entering in, how the payment terms are couched. So for you as a customer, but then again, depending on the type of contract, you want to peg your payments on acceptance. There's this issue of set-offs, which is that you or the supplier would have a right to set off payments from payments that are due. This is commercial point, whether it should be possible or not. For you, I suppose you would want to have this in there. But then if you, as a customer, and you're paying, you might not want to have this set off. On the supplier side, they might want to have, but actually, depending on the contracts, it might also be in your interest to also have, where you say you have different payments linked to each other. So set-offs don't really work if the payments for these different components that you want to set off are not related. If it's payments for different things, you have maybe under maintenance, you have a maintenance contract with a software programmer, and then you want to with different thing they're building for you, like something else, a different software, different functionality, for you to start setting off from the maintenance contract with this. Because they are not related, it might be something that I agree to. But then again, it's a commercial point. If depending on your interests and it's agreed, you can have that in your contract. Tax, this is just you specify the payment inclusive of tax or is it exclusive of taxes? That is also a commercial point. Some taxes that are applicable would be, say, for example, VAT, where VAT is applicable, or withholding taxes. Jurisdictions have some withholding taxes. So again, this is just to be clear whether these payments that are making, are they net or are they gross inclusive of all the taxes within. It's important to be clear on that, because actually there it can also be a very many point of contention between contracting parties, the issue of taxes, especially in jurisdictions where the taxes are high. Yeah. Okay, another important clause, and this is especially where the deliverable relates to the IP clause becomes very crucial. Issues like who owns that IP. That's something that you need to also discuss and agree on from the that the ownership of the IP will depend again on the nature of the services. There are things you could be contracting for that are not, you don't really need IP. For example, you don't need their software. Rather, you owning the IP is not crucial for that contract, right? So they already have the license to use to maybe connect their API or something like that, and then that's it. They tell you you cannot. But contract where IP is now very important for you. Like for example, if you have contracted someone to develop for you some bespoke software, which is unique, then you want to be very express that whatever is building belong to you. And you will, in that contract, automatic assignment clause. And in that assignment clause, you even add that third party is also appointing you. In that same agreement, they're appointing you as their agent for purposes of effecting that assignment, which includes signing all the IP registers, so that you actually properly have the right effect that transfer, because that is something that is important for you. Let me go to my slide because I wanted to stress some important points there. So again, ownership, it depends on the nature of the services, which is intellectual property. This even like your technical service provider, designers, your fabricators, and manufacturers, etc. And from the customer to the supplier to perform the services. So this is where you have to provide your intellectual assets for them to be able to. This can also be even with these fabricators or manufacturers building your product. Again, you would have to give them your designs so that they can see them and then build sense to them, required that to enable them to then perform on their part. And then there are instances where there is need for the to enable you to benefit from those services. And an example of this is where you're getting, say, these software arrangements where you're getting a license from a third party who has already built modify it for business now. In that case, you need a license from them. In all of those scenarios, you need to think about how you're going to hold the IP. On the interest, it's different how you're going to hold. So for example, on output, in instances like say it's being developed specifically for you, bespoke, some bespoke software, or the product that is being made with your design, with your original designs, those deliverables now are important to you. So in that case, you have to ensure that you acquire the interest. If it's where the outlet, for example, advertising campaigns, or you in that case, you might not need an assignment of the IP. There, you just need the license to be able to use their content, to publish their content on all your pages, to give it to your partner. It's not important for you to receive an assignment of the intellectual property that's in the output that they give in the deliverable. So again, it depends on what it is, the nature of the contract and the interest that you have. Input materials, this is now the stuff that the different parties bring in before, like what you come with into the contract. Generally, everybody usually retains ownership in their pre-existing IP, but then if it's crucial for the functioning of the deliverable, or it's crucial for you to be able to enjoy the deliverable, you pay a license from the party. And this could be, licenses are different. You can have a license that's time-based. You can have this, what is called a perpetual license. A perpetual one is that you can use it forever. But if you don't add the word irrevocable, it means that the forever license can be cancelled. So if you write forever, then it's good to just add a perpetual irrevocable, which means I have this license forever and you can never cancel it. Depending. Some you might be given a revocable license, especially subscription-based solutions where you're just purchasing a subscription. You're not really acquiring any interest in the service, then those ones are time-bound, and it's valid as long as you're paying your subscription and as long as the third party is providing that solution. So again, depends on the contract. Party materials, this is if the third party has to use other people's IP. Say, for example, they have to acquire licenses for other software, or let me think, like a marketing campaign as well. They might have to get like a license to use somebody's song in that ad, or they engage somebody tunes or melodies into your advertisement. Again, that's now another third-party license. In that case, the contractual issues there is whether you to pass the obligation to ensure that that license or that acquisition of third-party IP is valid, or to be safe if you don't trust the third party, or if you feel this relationship is not, you can then require that this your supplier ensures that you contract directly with that other third party, so that you're the one who has the obligations to ensure that the license, your rights to use that third party software are valid. Okay, moral rights depends on jurisdictions. In Kenya, moral right is the right to be credited as the creator of that IP. In Kenya, this cannot be waived. If you made it, if you created the IP, then you have a right to be mentioned there as the creator of this product. Not even in a contract, no one can take away that right from you. In other jurisdictions, it's possible to waive. So this depends on the law of your country. Implied IP terms, this is where you do not provide, where you don't have an IP clause to deal with, an IP clause for the contract, for whatever it is, whether it's a deliverables or anything else around it. Then the law and their IP rights that are generated, then the law will deem, or they will imply they will imply the rights. So for implied intellectual property, they look at what it is that you contemplated at the time of entering into your agreement, and it will be limited to those. So they are very so it's very important that you specify the rights and the ownership, because if you leave it out, and these terms have to be implied into it and be interpreted very narrowly only to what is that you talked about and nothing further. So if you extended the use into something else that for you is very linked, you might find that for that you also have gone back to receive consent, because they will only imply terminology for the only thing that you discussed, the first thing, and not any extensions. So it's PR indemnities. These ones are very important for you to have in your contract, especially in relation to those third-party claims, the third-party IP, because you don't know what they will do, what they will incorporate, either their part to have an IPR indemnity clause, so that if you infringed on their copyright, you go and add your third party, you add your supplier as a third party to the suit, so that if you're found liable, they're the ones who pay, not you. And so that's why it's important. And this last point is important there. You know, in most of these contracts, especially where your supplier has a higher bargaining power than you, or if they just they could have a limitation of liability clause. That is, if there's any claim arising from a breach in this contract, then it will be capped at amount. Sometimes the will be the fee that you paid them. But the implications for IPR breaches could go beyond the fees that you paid, because it's separately. They were not party to your agreement. If it's something that's determined separate, say by a tribunal or by a court of law, the damages could be way higher than the then they would only have to pay you back the fees you paid, and you will be stuck with the rest of the amounts you will be liable to pay to the third party. So for this one, if there's a limitation clause, make sure you carve it out. This one and the data protection one, because those ones, the damages or contract. And so you want to say for those ones, if there are breaches, you pay whatever has been determined, as long as they fall within the indemnity. This lead to the data protection clause. So if your contract with that third party involves the processing of personal data, then it's comprehensive that properly deals with the issues. Now, processing is very, very broadly defined, even in the Kenyan data protection model from the EU's GDPR. And I think most of the data protection acts coming into force in different countries, particularly in Africa, most of them are modeled on the GDPR, which is sort of thing, which sort of set like an industry standard or industry custom. So we find this broad definition of processing is included in most of the acts. It's essentially any dealing with personal data would fall within the definition of processing. So you have to, before you enter into a contract with a third party, you need to think about whether you will be dealing with any personal data, and what exactly will you be doing. So if it's If it is personal data that is being processed as service offering, then you need to, first of all, appreciate everybody's role. Will you be a data controller in that scenario? A data controller is the person who controls and who gives directions on the personal data that is being collected, how it will be processed. And then the other category is a data processor who then processes personal data on the instructions of the data controller. So data controller is that how control the process of personal data collected. And a processor is somebody who follows instructions. So when you identify the personal data that who will be it, then you're able to tell who is the controller, data processor. And now you can build in contractual provisions to ensure that each if the processing is for contract management purposes, which means that they will access the personal data that you have because it is part of them being able to perform their contract. Then again, you also need to check what roles would each party have. There are scenarios where you will both be say you enter into a partnership with an insurance company where you process to each other's services. In that case, it's not, you will not be processing information for the insurance company. Probably what you have agreed is that I will refer my customers to you. In that case, I have to provide you with the names, possibly the phone numbers of these customers. And the insurance company, if they're able to convert that and sell a policy of some sort, of course, they will also need to have that information and details, etc., in which they process to deliver their services, and you process to deliver your products. So both of you in that scenario are data controllers. So in that case, you need to share agreement, which just runs, okay, me, I do this, you do this. Essentially, everybody should comply with their obligations under and data protection. You say your security systems need to be as robust as mine or better, etc. So in that case, you need possibly a data sharing contract. In the first scenario, you need a data processing that be, these cases would be a DSA. Okay. Some of the terms to include in the data protection clause, and these ones are because the access, you specifically contract and provide these in your contract. So this is just like mirroring the provisions in the laws into your contract. So one is control in allowing the subjects size, right? So this is, say, for example, rights to correct errors or mistakes, rights to your rectification, right to withdraw their consent for things, rights which they're given by the data protection laws. Again, delete or return personal data when the processing service ends. So this is if we separate, return or delete it. Because if they remain with it, then there is now exposure on your part. And then, of course, make available compliance information. This is to allow you to audit, and this framework, and in controller to controller relationships, you don't need an agreement, but as I mentioned, it is now going sort of like confirms, yes, we have these obligations. It's like a confirmation of what you all are required to do. Okay. Okay. So protection. So these are other provisions that are important. But let me pause to see any questions. Are there any questions? Okay, yeah, sorry, I'm not sure where I dropped off, but what I was saying was, in cases where it's beyond the supply delivery, there be a control. Then if you have that force majeure clause in the contract, if you requires the supplier or the party that's suffered from the force majeure event, they should be required to send you a notice to inform you of the event. Should responsibility to put in place mitigation measures, and then also build in a timeline within which, if it has not changed, then you're entitled to terminate liabilities, no liabilities on your part. So that's one way to do it. On their part, if you don't have a force majeure clause in the contract, then nobody can rely on it. Yeah, and countries here in Kenya, or countries that are guided, countries that also rely on English common law, in a scenario where for you able to deliver, that's a breach of terms. So you can be entitled to terminate the contract if there isn't a force majeure clause. And for anyone to rely on a force majeure clause, you have to have then you would be entitled to terminate, especially if the supplier has indicated to you that I am unable to provide this due to these reasons. Now, if there is if you terminate the contract, again, it will depend on what that means for you. What would be the consequences of it? Because if you suffer loss, you want that supplier court. If you take them to court and there wasn't a force majeure clause, the other one that they can rely on, something called the doctrine of there were factors beyond control, but then sort of essentially factors to prove. So, but in that case, then you would be fighting over damages. That, other than that, prevent delivering, you can just agree to reduce. So if it's something that involved maybe building or say fabrication, so the products are in process, some tell them they and find somebody to complete the manufacturing. They might probably say, you will pay us up to where we managed to reach, which would again be a commercial point. You can have a discussion and say, well, maybe we pay something because of the inconvenience that you now have, because you need to find someone who will accept to work on those products, whether to work off somebody else's work. And if so like that, then you have the loss of having to engage a new person to start any other terms and then pay them fully for it. So again, that way there, it then becomes a commercial point. Yeah. But if you suffer loss and the supplier is being reasonable, then you can take them to court. But then if you take them to court, then you should know if there's a force majeure clause, that's what will prevail. If there isn't, they are frustration. Yeah. Yes. Is there any other question? Okay.
No, not
Assuming
really a
there are no
question,
questions.
but Not really a question, but for me is to share that, Felicia, we are like on top of the hour, the past 15 minutes.
Okay.
Yes.
Okay, that's fine.
How many slides were you left with?
Anyway, so let me just, I will, this is the last slide.
Okay.
Yeah. So maybe if you can allow me 4 minutes, I'll wrap up and then we're done. So on third-party costs, this is where third party is saying, I have to buy this or I have to engage this person. You will have these additional expenses other than my fee for the service. There is other costs. So these ones, it will be the usual things like first get my consent, bring receipts and things like that. And that they actually pay those costs. Termination and consequence of termination, this is just building in a procedure that's sensible that everybody knows, so that should you have to separate, then you can go to the clause. What we agree would be the processes for you is to ensure that there is a provision inside that requires their cooperation in transitioning the services, say, to another third party. Confidentiality is confidential, especially if, for example, you're sharing your designs with the manufacturer, or you've told a developer exactly what you want to do, which could be your product like competitive edge, then the solution that they're building for you is something you want to be kept confidential. Indemnities, this, as I said, is where somebody promises to pay liability cost in case you're sued, especially where it's sued because of the deliverable that they gave you. Warranties, these are contractual assurances or promises. And in contract law, it's if there's a breach of a warranty, then you're entitled to damages. So warranties here would be things like, say, for example, in a software development agreement, you want the programmer to warrant that their solution will work for you, will work for purposes. So that's a warranty. So that it doesn't work, you can go and sue them for damages and things like that. Exclusivity, this is, can this third party resell this thing that they're building for you? You try to bind them, especially if it's a bespoke thing that is very specific to you. That is, in fact, your business secret. Prove that to you. But if it's something that it doesn't cause you any harm, if they resell it, or at least sell maybe the general aspects of it, which they can use to provide solutions to other people, it's not a deal. Non-solicitation, they can't sell your people and your customers and stuff like that. Subcontracting, this is if you're quiet on engage somebody else, and also you can contract and they contract other people to perform the contract. So this is for you to think about whether it is for trying to contract because you want the services of that person and nobody else. But if that is not necessary in the contract, you can say, if you decide to subcontract, you must do maintenance, that at least you are aware of who is in fact doing the service. Yeah. So I think there are many other clauses that can be built in, but I thought these are some of the ones that I wanted to bring to attention. Yeah. Is there any final question? If not, we can rest here. I will share this presentation, and also, in case you want a consultation, you can engage with team. And yeah. Any final question? Okay, so I think we can wrap up here. See you the third, and thank you very much for attending. Over to you, Win.
Thank you so much, Felicia, for this session. Very much informative. There was a request from one of the team in earlier conversations that if you could as well help prepare a brief summary of this talk outside the presentations, if there's anything you could accommodate the presentation, that would be nice, especially in the earlier on the hiccups that with the internet was a bit difficult to hear clearly. But
Okay.
thank you, everyone. Thank you for making time for this session. Can't wait for the next session, which is going to be a build up of the same. And we'll be speaking towards, just a moment, we'll be speaking towards team building strategies. This is the sense in which will guide startup founders on structuring human capital, ensuring a balance of compliance and flexibility, so that you know if you're working with the key personnel, what will be their work of arrangement look like, so that you're strategic enough to look at the deliverables at hand. So thank you, everyone. Have a lovely day ahead. I'll see you all next time. You will be shared an email with the slides and any other content, and of course a link to the listening session today for all of you to listen in again if you need to. Thank you, everyone.